Hi, everyone, and good morning. Thanks for joining us today on another webinar series. My name is Ryan Gardner. I'm a managing partner and the head of our defined contribution group here at Fiducient Advisors. For those who I haven't met, thank you for joining us this morning. We've got two great speakers to talk about litigation trends within the defined contribution space and specifically within target date funds. I'm with a firm called Fiducient Advisors. For those who have not heard of our firm, we're a national consulting practice focusing on providing advice and counsel to sponsors of 401k, 403b, and other allocation pools. I'm joined this morning by Tim Brown and Brian Lamb, both coming from Thompson Hine. Tim is a partner and former member of Thompson Hine's executive committee and former practice group leader in the employee benefits and executive compensation group. Brian is the leader of the firm's business litigation practice, which represents companies and their directors and officers in complex business disputes. We are short on time this morning. We've got about a 30-minute block, so I wanted to allow as much time as we possibly could towards the information and slides. There is a chat feature, as everyone probably sees, down at the bottom of their screen. So as we're going through, please feel free to enter any questions that you have, and we'll have some time towards the end of the presentation to address as many as we can. So with that, why don't I turn it over to both Brian and Tim.
Thanks, Ryan. Thanks for having us here today. So we have two goals today. One is to give a strategic overview of the 401k excessive fee litigation, not a historical overview because it would take too long, but like where are we right now? And the second goal is to then apply that to what's going on with the specific variety of ERISA litigation that involves target date funds. So those are the two things that Tim and I are going to cover. I look at this from a litigator's perspective, and Tim looks at it from the perspective of an employee benefits lawyer trying to help keep clients on the straight and narrow. So first, no discussion of the 401k fee litigation would be complete without a quick note on Hughes versus Northwestern. This was the Supreme Court case that came down in January of 2022. Certainly, both the plaintiff's world and the defense world were hoping for some clarity from the Supreme Court on what is expected of fiduciaries and what does it take for a plaintiff to draft a complaint that would survive or fail a motion to dismiss, which would be a way for fiduciaries to end a case early. Unfortunately, the case was neither a clear win for the plaintiffs or the defendants. The court took kind of a compromise approach. It was an 8-0 decision, which is pretty unusual in this environment. But they came up with a very narrow ruling that basically said, while the Seventh Circuit improperly upheld the dismissal of a fee complaint, one of the several arguments the Seventh Circuit relied on was improper, said the Supreme Court. So the Supreme Court said, take out that one argument, and then they sent the case back to the Seventh Circuit for a do-over. So consider this question of whether this case survives a motion to dismiss without this one improper holding. And that improper narrow holding was that the Seventh Circuit had essentially said, this plan has a wide array of investment options. So if there were any bad ones in there or imprudent ones, they're offset by the fact that participants could avoid them by selecting from the 100 other options that are not alleged to be imprudent. And the Supreme Court said that's the wrong way to look at it. A fiduciary has a duty to independently monitor every single investment option. And so the Supreme Court didn't say whether this case should survive or not. It just said Seventh Circuit has to do it over again using the right test. So the case is now presently back in front of the Seventh Circuit, which is in Chicago. Oral argument is later this month, and so we will see what the Seventh Circuit does when it considers the motion to dismiss under the new test. The main takeaway from Hughes versus Northwestern under Tibble, fiduciary has an ongoing duty to monitor investments and remove imprudent ones within a reasonable time. Okay, so you can't just say, well, there's a lot of good apples in this batch, so I don't have to look for bad ones. Fiduciaries must look for the bad ones, okay? The problem for the rest of us is this gives very little clarity on the pleading standards. What does it take for a fee complaint to survive a motion to dismiss? So we are now in a post-Hughes world trying to figure out what it means. There is a silver lining for fiduciaries, which really are the people Tim and I represent. And that is the Supreme Court did say in its ruling, it reminded lower courts that when reviewing 401k ERISA claims, the courts must consider that there are a range of reasonable decisions a fiduciary may make without violating the duty of prudence. That is, there's like a buffer zone, there's a range of reasonableness, and you can't second guess every decision and said there was one that was a little more reasonable. The test is whether or not the fiduciary's conduct was within the zone of reasonableness. So the defense world has been latching onto this, and interestingly, lower courts are starting to cite Hughes as a basis for granting dismissal of fee complaints, which is kind of unusual because the plaintiffs' world thought they had a victory in January when Hughes came out and took away the dismissal from the Seventh Circuit and said, do it over. Well, what lower courts are saying is, well, that's kind of a narrow ruling, what they held in that case, but look at this general statement. We should give fiduciaries some elbow room to do their thing. So what we are seeing now, post-Hughes, 3 circuit courts of appeal, and there are 11 of them that cover the country. 3 of them so far in Common Spirit, Oshkosh, and Mid-American have cited Hughes when upholding the dismissal of an excessive fee complaint. So this is between January and today. 3 circuits have applied Hughes and all the other cases out there and upheld the dismissal of a fee complaint, saying the plaintiff didn't do enough to survive a motion to dismiss. And last week, there were 4 district court cases, that's at the trial court level, just last week, that also dismissed excessive fee complaints. So there's a little bit of a wave building here in the recent months after Hughes. Whether it turns into a tsunami remains to be seen. But the key takeaway is courts are saying plaintiffs must allege a sound basis for comparison, a meaningful benchmark. So if you're going to challenge record-keeping fees or investment performance or investment fees, you can't just say, oh, they look too high or they look too poor. You must allege some comparisons out in the market that are meaningful, meaning that it's an apples to apples comparison. And that is, this came up in the Wells Fargo, Miners versus Wells Fargo case a couple of years ago, this concept of the meaningful benchmark, and it is really getting traction now. It's been a pendulum going back and forth, but it's been applied in recent weeks here in support of dismissal of 401k claims. So I say we might be swinging back in the pro-fiduciary direction. That still remains to be seen. Meanwhile, these cases are maturing to the point where if the motion to dismiss was denied, now you have discovery and then you get to the summary judgment standard. And the defendants are starting to win at the summary judgment stage. So AT&T, Home Depot, Goldman Sachs all have recently secured very big victories in excessive fee cases. And they've done it not at the motion to dismiss stage, but at the motion for summary judgment stage. That means that's after discovery, after depositions, after you've turned over all your minutes and all your expert reports. And then a judge looks at the record and says, okay, in light of all this, I think that the defendant should win. So 3 recent cases, these cases really provide a roadmap. Mostly it turns on a fiduciary being in a good position to prove with documentation they followed a prudent process in making their fiduciary determinations about fees and investments. So the real big takeaway is the defense could win at the motion to dismiss stage. And if they don't win there, they could win at the motion for summary judgment stage. So with that, we'll give a quick overview, some takeaways at this first part of the presentation.
Thanks, Brian. I just want to cover the next two slides. I really just want to summarize because it really goes, what Brian's saying is really goes down to having a good fiduciary process. Fiduciary being the company's management or a committee. Typically, the larger the company, the larger the plan. You have a formal 401k committee, an investment committee, or a benefits committee, which we highly recommend that you do have a formal structure set up in place. So the key takeaways here to help you avoid litigation, or if you did get in litigation, you can get out of it pretty quickly, is to have these high level, I'll do it at the 6 key items. We could probably spend an hour on talking about each of these in more detail. But one is to make sure you really have a prudent process set up to review your funds and to review your fees, review the performance. And that means quarterly meetings, having robust quarterly meetings and annual reviews in depth of which Brian will get to, your target date funds and your fees. Making sure you have retained experts, whether the consultants or third-party investment advisors, to help you review on a quarterly basis and be part of that robust process. Making sure you do have good market benchmarks, which your advisors would be able to help you select, and which you're measuring your funds, fees, and performances, which would include, which Brian will get into, your target date funds. Making sure, more importantly, you're documenting your process. You have written reports, you have minutes from meetings, you have analysis, you have documentation of all of this review that you need to have to show that you're a good fiduciary and have a good process. And then take affirmative action. If there is something wrong that needs to be revised, reviewed, removed, replaced, that you are taking affirmative action over a period of time. And then lastly is making sure your disclosures are accurate and complete, because the plaintiff lawyers are looking at your Form 5500s. They're looking at other disclosures that you give to your participants. You need to really make sure and look at those to make sure they're accurate, complete. And if they're not, you should beef them up to make sure they are, because that's where a lot of misinformation or disinformation the plaintiff lawyers are getting is off those limited documents. They make assumptions, then they file a suit. And the big problem you have then is then you have to have the time and expense to defend that suit. So that's essentially what we're talking about, is these takeaways, is making sure you understand you have a process, you are looking at the different elements, and you are documenting those elements as you go along. Because this is going to be, keep this in mind as Brian spends the next 10 minutes talking about target date funds, because this is going to go right to the heart of what Brian is talking about of making sure you have a good target date fund in your lineup. Brian?
Great. Okay, so let's turn to the variety of excessive fee and subperformance litigation that focuses on target date funds. Nobody is safe. All different kinds of target date funds that have been offered have been the subject of these lawsuits, including custom funds. There is a method to the plaintiff's madness. Their complaints boil down to some combination of these factors, that they are thematically, improper investment strategy, excessive fees, underperformance. I mean, these are all the same things you see in the more general category of the fee litigation. So these are the general concepts the plaintiff's lawyers are looking for when they're drafting their complaints and choosing their targets. The DOL did issue guidance on target date funds in 2013. This slide could have one bullet that just says process, process, process. That's really what the DOL's guidance is. Make sure you have a good process, make sure you document it, kick the tires, rely on qualified experts and consultants, and understand what it is that your particular target date fund offering is. Is it a to or a through? What's the investment philosophy? So it's really about process and making sure you're using good consultants to help you bring expertise to bear. It's been 9 years or so since that 2013 guidance. So and with this recent flood of target date fund litigation, 24 cases, more than 24 cases, there's been some clamoring in the industry for more guidance, and a couple of people from Congress have indicated publicly that they are agitating for a review and by another review and updated guidance on on target date funds, and the DOL put out a cryptic statement that they're coordinating with the SEC to provide clarity on target date funds. So stay tuned on that. We're in watchful waiting mode to see what comes. So the whole focus on target date funds started in 2020 with 16 or so cases filed against fiduciaries of plans that offer Fidelity Freedom Funds. And the plaintiffs' lawyers used their template complaints and made allegations that Fidelity Freedom Funds, that these are active funds, that it was imprudent to select active funds when you could have offered passive funds, and passive funds cost less and are just as effective, yada, yada, yada. It's really, you see the same kinds of arguments that we saw in the prior bullets. The plaintiffs just challenging a particular kind of investment. Here they latched onto Fidelity Freedom Funds. 3 of the cases have settled on a class basis. Something for the high 6, low 7-figure range on a class basis, which, by the way, could be a nuisance value, defense cost type settlement, depending on how big the class is. One of these cases was dismissed by the court, and this is the Common Spirit case in the Sixth Circuit. We saw it was one of the 3 circuits that we saw earlier that has, in a post-Hughes world, upheld the dismissal of a fee claim. Well, one of them was a target date fund case, the Common Spirit case. And the Sixth Circuit said the plaintiff just has not alleged a meaningful benchmark. The comparators that they identify in the complaint don't have the same objectives and goals and characteristics to make a meaningful comparison to the challenged investments. So these cases are continuing. There was no easy out. It's not like the fiduciaries were able to win motions to dismiss across the board. In fact, they've only been able to do it in one of the cases. 3 settled, and the rest are just working their way through the litigation process at this point. The most recent development has been this wave of cases against plans that hold BlackRock target date funds. And there have been 11 lawsuits by my count against these 11 sponsors. And it's the same idea as the Freedom Funds, except here the plaintiffs' lawyers are flipping the script. Okay, BlackRock, these are 2 investments. So the target date is to retirement. And so they're basically more conservative. They get to the end allocation more quickly. So they are more conservative. And the plaintiffs' lawyers are now flipping the script and saying, you ignored performance and went for the cheapest fund. And by doing so, you have breached your fiduciary duties. And of course, this is the exact opposite of what they're saying against the Fidelity Freedom Funds. Oh, you picked expensive ones when you should have been going for less expensive ones. Now they're picking on the less expensive ones. Here's a quote from the complaint against Microsoft, and it appears in a lot of these. This is a quote. Instead, as is currently in vogue, defendants, that's the fiduciaries, appear to have chased the low fees charged by the BlackRock TDFs without any consideration of their ability to generate return. Okay, this is the exact opposite of what they allege in the currently pending Fidelity Freedom Fund cases. So it does leave one to wonder, is there anything a fiduciary can do to insulate itself from litigation? So, the idea here is in this middle box that instead of accusing the fiduciaries of paying excessive fees for actively managed TDFs, now they're arguing that they're chasing low fees in the passively managed TDFs in exchange for inferior returns. So what you're left with is now what this has gotten the attention of the industry. There are several really good amicus briefs, that is friend of the court briefs, that have been filed in these cases at the district court level, as the trial court level, which is relatively unusual. Usually those are reserved for appellate courts. But the industry is chiming in these cases involving BlackRock and saying, Judge, you must grant the defendant's motion to dismiss. Like, nobody is safe. Plaintiffs are not using meaningful benchmarks here, and they get you coming and going. And if these cases are not dismissed, there will be a cascade of lawsuits. And as these briefs point out, BlackRock funds are very high performing. They're gold rated. They have periods where they outperform the comparators that are identified by the plaintiffs. It really does look like the Wild West. And so the sponsors in the BlackRock cases have really done a great job of honing in on what does it mean to be a meaningful benchmark or a non-meaningful benchmark. And so they go through attribute by attribute, and they point out that plaintiffs are pointing to target date funds that have different philosophies and different holdings. So they're comparing BlackRock's 2 target date funds with including Fidelity's and others through target date funds. And right there, the defendants are saying that's not a meaningful comparison. They have 2 different approaches. You can't say one's better than the other. They have different goals and different objectives. You can't compare active versus passive. They have different objectives, different philosophies. And the defendants point out that the BlackRock target date funds have different equity allocations and different particular equity funds, whether it's emerging markets or large cap, small cap, all this, lots of granularity is coming out in the defendant's briefing, where they are pointing out that it's not so simple for a plaintiff to just pick 4 other target date funds out of the 40 plus target date fund suites out there in the market and say, oh, BlackRock underperformed these 4. Well, what about the other 36? They're not mentioned anywhere in the complaint. So what you see is that's real early days. We don't have any rulings yet in the BlackRock motions to dismiss. But with the momentum that the defense world is getting post Hughes, it could, and with the industry really chiming in a way in support of these fiduciaries in a way that they were less involved early in the Fidelity Freedom Fund cases, and I think they probably wish they were more involved earlier and maybe could have headed this off. So these takeaways really are the same as what Tim just told you are the takeaways in general to avoid excessive fee or non-performance litigation. Pursuit of the lowest cost does not guarantee you or inoculate you from lawsuit. I always, as a litigator, I always tell all fiduciaries, assume your investment decisions will be challenged in court. Picture yourself testifying under oath in a deposition. Picture yourself on the stand explaining to a federal judge who's not an ERISA professional, like why you did this, why did you miss this meeting, why did you follow the advice of this expert, why did you disregard the advice of the expert, document it all. I really do think it's not an overstatement to say that litigation is not preventable. Plaintiffs can sue for anything pretty much. So you've got to be ready to demonstrate that you followed a prudent process, that you monitored these investments, and you follow all the steps that Tim brought up. Tim, that's my last slide. Anything else you want to chime in on takeaways for target date funds?
No, I think that summarized it nicely, and I think the focus is on process. And I think if everyone focuses on their process and takes the steps to enhance that and make that really, really good process, they should be in good shape going forward. Thank you.
That's great. Ryan, any questions come in?
Well, so one of our analysts messaged me, said the chat was disabled. So I think Kristen's working on that now. Hopefully it'll be up and running. But I've jotted down a couple of my own. So when we get to that point in the presentation, I can certainly get us started.
Well, we just hit it.
Ah, perfect. So a couple of things. I think it was Tim back on the DOL target date fund tips slide. One of the points on there talks about how sponsors may consider evaluating custom and non-proprietary funds in their daily review of the investments they're offering. Can you offer a little bit of context, maybe how committees and sponsors should be thinking about that point specifically going forward? Do they need to take a deep dive on custom, for example, if they've done work and already identified a suite that fits nicely in their plan?
No, I think as long as they do the diligence on the suite, whether it's active or passive, but I think they should still look at, if they like active, they should look at other active and look at a passive option, just to come to the conclusion that we think for all these good reasons, with the help of our advisors, we think this active option is good for our plan, our population, and our group for all these reasons. So I think the larger plans look at these, the white label, the private label, or custom from that end, but I think your plan needs to be pretty large to really go in that custom direction.
Okay. And maybe one other I jotted down, I see questions are coming in, so we can get to those if we have time. In today's market environment, where we've got a lot of volatility, certainly amongst our client base, we've heard some nervousness about making change. And Brian, I think you talked about change in the context of within a reasonable time frame. So could either of you weigh in on, should sponsors table potential change given the volatility? And if they do table a change for whatever reason, could be investment change to target date or even to their provider, what's defined as a reasonable period of time?
Yeah, I can tell you, Ryan, in the cases, what you see is the plaintiffs will cherry pick the time that makes the investment look the worst, where it's in the bottom quartile during this period. And what you generally see are the defendants and their experts are saying these are retirement funds. We need a long-term horizon for these investments, and you need to be patient. And in one of the recent summary judgment cases, the judge agreed with the defendants that it was improper for the plaintiffs to pick like a 1 year or 3 year period and say, oh, this investment performed below market in this one period, when the defendants are pointing out that, but we came out of that, and over the long run, that investment was really a good performer, and we would have lost out on that upside had we taken a short-term perspective like the plaintiffs want us to. We would have sold at the bottom and so the courts are very receptive to the idea that with retirement plans, you could have a long-term horizon, as long as the committee is documenting, this is what our goals are, this is what we're measuring this, and let's say we have a 5 or 10 year horizon. If something's not performing over like 3 years, doesn't mean you should ignore it and wait till year 10. You ought to be kicking the tires. You ought to be documenting. I'm a fan of noting that something's on a watch list because it's not as good as it's not performing the way you hope right now, and then keep monitoring it. And then if after some time that you deem reasonable, it doesn't come out of the doldrums, you can make a change, and don't be afraid to make a change. ERISA wants you to make a change if you've concluded that this investment's not going to meet your goals.
And maybe the last question, there's a request for some slides in the transcript, and I think we can send that out to the group. But I think you both mentioned in your slides one important change that's occurred in litigation, which is courts are considering reasonable benchmarks, whereas potentially in past cases there was information and benchmarks used which really wasn't applicable to the plans that were in question. Can you give us maybe just a sense for how plan sponsors should maybe define that reasonable term when benchmarking their fees and other parts of their plan relative to, is it plans of a similar size, plans using similar services? How should sponsors be thinking about that?
Yeah, so the way I look at this, Ryan, is ultimately ERISA requires a duty of care. that a fiduciary act prudently. So you have this, what does that even mean? It's like a really vague general standard. And people, particularly fiduciaries, crave specificity, like a black and white rule, like a specific percentage or a specific this or that. This world is not that neat. This world is quite vague and general. And so the fiduciaries who, they should fall back on process, and they should identify for themselves what they think is a reasonable benchmark, whether it's fees, but what are their peer plans. And a lot of times they get, consultants will give them a better perspective on what is really a good peer group for you. And then you should have the courage of your convictions. Let's look, we do think this is our peer group. We do think this is a good comparator we have this target date suite. Every once in a while, we're going to compare it to these other three and see if we should make a switch. Have the courage of your convictions, document that you're doing that, and then you'll be prepared to defend it in court if it's challenged.
Yeah, I think you really rely on your experts, your independent investment advisors, consultants to help you pick what group you would need to benchmark against and what's reasonable, both from the investment side and the fee side. And then at a minimum, you should be going out for an RFI, RFP every 3 years, which would take your exact plan, statistics, demographics up against the market with other vendors. Then you have real solid proof and evidence of what that market is. But in between, you could use market data and information, but your advisors really come into handy there to help you fine tune what those benchmarks would be for each of the different elements. And that should be done periodically, if not every year. Okay, thanks.
Well, it certainly seems like we're finally getting back to process, driving the process rather than results, which is what ERISA is all about. So, Brian and Tim, thank you both for your time. Great. I know we're a couple minutes over and we've got a handful of questions we didn't get to, but we will send responses to those individuals. I believe we will send out a copy of the slides and anything else that either the folks from Thompson Hine or Fiducian can help with, please reach out. We'd be happy to do that. Thank you all again for the time this morning and hope you have a great rest of the week.
Thanks, Ryan. Thanks for having us.
Thank you.